We're bringing you this warning from Georgetown County, South Carolina, because it's just been brought to our attention. We don't know how far it goes, but it's an important story that has to get out as soon as possible. It was brought to our attention when a violation or citation from building and zoning was placed on the home that I grew up in. And it cited, and I quote, the International Property Management Code as an adopted ordinance of Georgetown County. Now, being familiar with basic, building and zoning, I was rather curious when I saw the word international. At first, I dismissed it, but then after looking further into it, I found some very remarkable and very troubling truths. But let me familiarize you with South Carolina and Georgetown County state law at first on how it works. Building and zoning regulations in our state has been ruled in the lower appeals courts, etc., that is the purview of each county, that is local government, and as it should be, should control any ordinance that would regulate your normal lives. So they stay out of this. So the counties are left to regulate it for themselves. And in our county, we had the standard building and zoning codes. They only began enforcement back as far as we can tell in 1989. Now, I should tell you who I am. I'm Ken with Citizens for South Carolina, and I've served as a county fire chief in Georgetown County in good standing, and I was a fire marshal during my time in the county fire department. So I'm familiar with building codes, fire codes, and who we enforce them with. And we enforce these originally only on corporation or businesses for the protection of the people. We at that time never attempted to enforce any kind of fire code on private citizens or homes. It was clearly delineated as a corporate thing to protect large crowds and audiences. And we were not allowed to, as the Constitution provides, to enforce such code on churches or church organizations, but only on school buildings, government buildings, and on corporations. And the fire chief that was my commanding officer at the time over me was hesitant even to enforce these codes on the government buildings where they should apply. So though I'm not a lawyer, I am familiar with code enforcement and such in the past and the origins of it, because prior to that time we weren't enforcing those. But I want to bring out the end of privacy in our county and the end of the state constitution in our county if this laws that we're finding out exist go unchallenged. I want to preface the comments and explanation about the International Code by first referencing the powers granted to our building and zoning in the county ordinance. In the county ordinance, Article 15, Section 1, or 1501, right of entry for purpose of inspection. Any official or employee of the County Planning Commission, Zoning Board of Appeals, Architectural Review Board, and or their staff required or authorized by this ordinance to enforce any provisions herein shall have the right to enter any premises for the purpose of making an inspection thereof in accordance with law at any reasonable time in pursuance of such duties. And this was an amended ordinance in 2009. Now, of course, this is something that went unnoticed by us and wasn't really prevalently advertised in the newspapers. But it's empowering these people to enter a premise. Now, on its face, we would not worry about this because ostensibly building and zoning is concerned with construction. Construction of buildings, inspecting buildings, and generally corporate structures, not as much home structures. But you expect that to be for premises that are under construction or that want to approve some construction. Granted, I understand the constitutional ramifications of claiming that the state or even a county government has the right to regulate you modifying your own home. I understand that issue, but let's not get off on that just yet. Let's look at this. This is empowering them to do inspections without warrants. Now that in and of itself would seem benign enough, but when we overlay it with the codes we're finding out actually exist, it is stifling. As I said, on the county's website, and you can find all the links to everything I'm referencing on the description of this video, and when we get time, we may overlay them in an edit. Right now, we're going to do a down and dirty edit and try to get this story uploaded as fast as possible to make sure it gets out to the most people in Georgetown County and across the state of South Carolina as possible. So we're just going to tell you it's in the description. Look down there and click on the links to find them yourself. Because I was familiar with the one page of titles in regard to building construction and building and zoning in the county. Nothing unusual, nothing strange. The county had developed or had added a development code that required a ridiculously high environmental impact fee on new buildings, including trailers, etc., that was ridiculous. That raised eyebrows and has been debated. But at no time were we advised of this county ordinance that slipped by that added entire thousands of pages of code to our county law that we knew nothing about. In section 7-1, and to explain this again, I had to hunt to find this because the code referenced in the violation was nothing we'd ever seen before. But after much searching, I found a county ordinance establishing the building and zoning ordinances now that listed the specific codes that were adopted. Specific codes. The codes shall be adopted or updated at every major change. And then it goes on and it says, the following codes as noted and as herein contained shall constitute and become an ordinance of the county of Georgetown. Now, I'm not going to read through the whole list of international codes, and every one of these is an international code, from the International Plumbing Code to the International Fire Code. None of these is domestically generated. The main one that popped up was not building and zoning, but this item number 9, the International Property Maintenance Code in 2006 edition. Now, according to the way we set up building and zoning in our county, it was to apply to buildings and to construction. Nothing about property maintenance, nothing about health issues. That's what the Department of Health and Environmental Control at the state level manages. There may be county or city agencies, but we in this state maintain our health services at the state level when it comes to people's property, not the corporations and health standards as far as food services. I'm talking about private residences. They cite this property maintenance, which is not something we had ever in our county considered as part of our building and zoning code or their purview. The citation mentioned trash and a boat in the yard. And at the time, we assumed that this was a prior reference to a county ordinance on trash and common nuisances, which has long been defunct, and we fought it for years because we had a dispute with a neighbor over this issue of parking boats and vehicles on your property. And by boats and vehicles, I mean a single boat or a single vehicle on county right-of-way, and it's been an issue, so we just assumed there was nothing to it until we found this. The section in the International Property Maintenance Code, and you have to look at this for yourself. It's going to be in the section, it's the third section of the book of codes. It's section 307.1 under rubbish and garbage. And I'm going to read this directly. Pay very close attention. Accumulation of rubbish or garbage. All exterior property and premises and the interior of every structure shall be free from any accumulation of rubbish or garbage. Let me read that again. All exterior property and premises and the interior of every structure shall be free from any accumulation of rubbish or garbage. Now, folks, for those of you, your mind's starting to reel, let's look at what this says before we look at it coupled with the other laws of enforcement for this. This is an international code declaring that every homeowner or tenant in the state or in the counties in the county in which this is enforced is not allowed to have rubbish or garbage anywhere in their house. Now, granted, I haven't gone through the appendices to see if these are properly defined, but here there's no definition of rubbish or garbage. And in the case of the citation that was filed, there were technically no garbage bags or rubbish that was cited. It was used against other items. But according to this, if you have trash that you've kept in your house that you haven't gone to the garbage yet, or they deem something in your house as rubbish or garbage, they can cite you for what's in your house. Now let's look back at the enforcement code that establishes their right to inspection. And now let's look at that in the light of the other, because you're thinking, well, it's exterior to the premises, so it won't apply to me. What does the code say? Right of entry for purpose of inspection. Any official employee, and we're going to cut out the middle, to enforce any provisions herein shall have the right to enter any premises for the purpose of making an inspection thereof in accordance with law at any reasonable time in pursuance of such duties. As a fire marshal of the state of South Carolina, I was not allowed to enter private residences without express permission. I was not allowed to go in and inspect private residences for any kind of building code or fire code, and I was only given the right to go in for the sake of the people into corporate-owned properties and structures, publicly open structures that can endanger large numbers of people. This says that in Georgetown County, you have no Fourth Amendment right. And for those of you who don't know, in the state of South Carolina, our Constitution Bill of Rights reads like the federal United States Constitution's Bill of Rights. With the same things, we have the right of suffrage, the right to freedom of the press, freedom of assembly, freedom of association, freedom of self-defense in the Second Amendment with the defense of our weapons, the keep and bear arms, and, of course, number 4, to be secure in our persons and property, and that we cannot be searched without a duly issued warrant from a judge in good standing, expressly identifying the person and location and address to be searched and the items to be searched for. This, folks, is an attempt to violate that Constitution and say that if anyone accuses you or they want to target you, they can enter your residence without permission to search for, and I quote, accumulation of rubbish or garbage. Now, this is beyond anything that King George did when we ended up having a revolt openly against him. But in Georgetown County, they're claiming the right to go into your house or go into your property without your permission in the hopes of finding garbage. How many of you have any piece of trash on your property that could fall under this law? To look further, now this statute covers guardrails on your home, extermination. Let's look even further. 308.1, infestation. All structures shall be kept free from insect and rodent infestation. All structures in which insects or rodents are found shall be promptly exterminated by approved processes that will not be injurious to human health. After extermination, proper precautions shall be taken to prevent reinfestation. So yeah, they're going to come onto your property to check to see if you have rats or mice, and then to follow up on extermination. This is absolutely incomprehensible and unconstitutional. You don't have to be a constitutional lawyer to see this problem. And it needs to be dealt with immediately, because the penalties for violation in the county code is any person found violating any provision of this ordinance shall be guilty of a misdemeanor, and upon conviction shall be fined up to the maximum amount allowed by state law or imprisoned up to 30 days in jail, as determined by a court of competent jurisdiction for each offense. Each day such violation continues shall constitute a separate offense. So if it's 30 days, it's 30 penalties. Nothing herein contained shall prevent the county from taking such other lawful action as necessary to prevent or remedy any violation. So clearly we know from the Constitution that the right of having a lawful warrant to have your property searched applies anytime you can be imprisoned or fined or taken to jail for something. Yet here we're being told that they can come in, search your property, go into your house without a warrant, look for something, hoping to find something, charge you, and then if you lose and this process goes through with their appellate process to building and zoning, not to judges, but to building and zoning, you can be found guilty and charged and sent to jail and charged a very high fine, the highest allowed by the law of South Carolina. We're going to pause here and continue it in the next video, so take this back up in the next segment.